Democratic Senator Sheldon Whitehouse on the Justice Department issues here. You're on the Judiciary Committee. Thanks for joining me tonight.
Good to be with you, Ari.
You and then Attorney General nominee Bill Barr talked obstruction at its hearing. Let's look at that.
And it is not your intention to change department policy or department standards or department definitions, particularly as they may bear on obstruction by the president or people around him.
That's right.
Thank you.
You got a sort of commitment there. Do you feel he's honoring it?
It's hard to tell because of all the different charges that one could bring. There are a lot that are a mixture of fact and law, and an obstruction charge is about as fact-heavy a proposition as we have. So his letter said that most of the obstruction or potentially obstruction conduct has been public, but that implies obviously that there is some conduct that has not been known to the public, and until you see the whole thing, it's very hard to sort that through and apply it against the prosecution standards of the department.
Let me give you the benefit of responding to the arguments that are coming from the White House. The president's lawyer, Jay Sekulow, was here. Here's what he said. Take a look.
The difference between Leon Jaworski and Ken Starr was they reported to judges and panels. The special counsel reports to the Attorney General of the United States. That's different. And then there's a specific regulation that governs what confidential report is delivered not to the United States Congress, but a report that first goes from the special counsel to the Attorney General.
What is your response to his argument that the rules Mueller's operating under allow Bill Barr to render this final judgment and make Congress less essential, in his view, to assessing potential obstruction?
Well, they are different, obviously, and Bob Mueller has conducted himself very differently than Starr and Kavanaugh did. They ran a really public smear effort through their special counsel effort, whereas Bob Mueller kept a very confidential, private, and professional effort going. So there are a lot of differences, but Barr remains accountable to the public on this, and it is well within his discretion to hand over the report to Congress, and he ought to do that. I think the implication of all of these regulations is that ultimately, particularly when you're dealing with a public official who's potentially subject to impeachment, that Congress will get a look at what took place. And here, with the public promises that Barr has made, we're expecting that he'll make a lot transparent and that he'll be very cautious about dealing with the grand jury 6E rulings, with the potential executive privilege protections, and with the, uncharged person traditions of the department, so that we get to see as much as possible and that the American people can see as much as possible.
And so on
the
that,
House
before
actually
I let
has
you,
a particular role around 6E. So,
yeah, well, 6E, grand jury. Before I let you go, do you view the letter that he sent over the weekend as satisfying the rules requirement that he explained to Congress, these declination decisions?
No, and I don't think he does either. I think he thinks that this was an opening response to quiet a lot of very active speculation, but knowing full well that he'd have to back it up with a very, very transparent release afterwards, and we're going to hold him to account for that.
Understood. Senator Sheldon Whitehouse, thank you for joining us tonight.
Thanks.
Hey, I'm Ari Melber from MSNBC. You can see more of our videos right here, or better yet, subscribe to our YouTube channel below. You could have been anywhere in the world, but you're here with us, and we appreciate that.